call the hearing into order. And what we're about today is a motion to dismiss by the city, and the petitioner is James Stephen Worley. And welcome today. I'm going to have the commissioners, if you would please, starting with you, Mr. Lee, introduce yourselves, and then we'll have council and the parties introduce themselves, and then we'll proceed.
My name is Manu Lee.
Alex Moore.
Phil Rubin.
I'm Denise Klein.
Trish Holland.
And Cynthia Ball.
Mr. Seymour, do you want to introduce yourself, please?
Andrew Seymour at the Raleigh City Attorney's Office, the respondent in this case.
Okay. And petitioner and your counsel.
James Lawrence for petitioner James Stephen Worley.
And James Stephen Worley.
Great, thank you. All right, I'm going to turn now to you, Mr. Seymour. I think this is your motion.
Thank you, Your Honor. I'll stand over by the podium for my argument and presentation.
Madam Chair, do you wish to set a time?
I'm sorry?
Do you wish to set a time for the argument?
I don't think so at this point.
Thank you, Commissioner. So we're here today on the city's motion to dismiss the current case. I'm going to start by giving a little bit of an overview of what we're here to talk about today, and then obviously go into my arguments of why the city believes that the commission should dismiss this case. So we're going to be talking about the city's COVID-19 testing requirements that were in effect from September of 2021 to April of 2022. Petitioner's hearing request concerns his challenge to that testing requirement. And
Excuse me, I need to ask a question.
Sure.
Why don't you go ahead and announce what you, or ask the, say what you've said to me. Commissioner Ball has a statement to make at this point.
And I apologize for interrupting you. I'm a member
Go ahead.
of the General Assembly.
Sure.
And we had several votes on which I was one of those people who voted, and I didn't want to not disclose that to you all because some of these COVID requirements were voted on in the General Assembly.
And specifically today, we're talking. We're going to be talking about the city's requirements. I know that this is a very polarizing issue, hence why we're here today. But there's we have requirements all the way from federal, state, local, and today we're just going to be focusing in on the city's requirements that were implemented at this time. But thank you, Commissioner.
Mr. Rubin also has something to say.
Yeah, Commissioner Ball's point actually causes me to think of one too. I used to work for the state of North Carolina during the pandemic, and represented the state of North Carolina in litigation over closures related to the pandemic. I did not ever represent the state that I recall in anything related to vaccine requirements or testing requirements. But I did want to disclose that if anyone has concerns that creates a conflict, I'd certainly be happy to hear that, but I represented the state in those matters.
Thank you. Do any of the parties have any concerns or anything you want to say about these disclosures?
The commissioner just spoke. Commissioner Rubin mentioned representation of the state with respect to closures, and I'm just, could you elaborate a little bit more? Was that with respect to the governor's executive orders and things of that nature, I assume?
Sure. I represented the state of North Carolina defending lawsuits challenging the governor's closure orders, things such as gyms that were suing, bars that were suing, basically saying that the executive orders that caused closures and the COVID emergency orders were unconstitutional, and I defended the state's position that they were not unconstitutional under the state constitution.
Did you represent the state against the bowling association by chance that brought loss? Okay. My law firm, I was not involved in that case. My law firm, the law firm didn't exist at that time, but my law partner litigated that case to the North Carolina Supreme Court. But in any event, as you said, this is specific to the testing requirement. So in any event, thank you for
Sure.
for
And
that
if
information.
either side asks me to recuse, I will simply recuse.
The city does not believe there's any conflict because we're not talking about the state or federal issues that you were a part of. We're talking about the city's testing requirements that were in place for a period of time. And so I don't believe that it touches on the issues that you were concerned of. Obviously, I appreciate the disclosures, but I do not believe that there's any conflict on this.
And we don't object.
So let the record show that none of the parties to the case have objected to the continuing participation of Commissioner Ball or Commissioner Rubin. Thank you.
So a little bit of background of what we're talking about today is the city's COVID testing requirements. As I mentioned earlier, it was in effect from September 17, 2021 to April 1st, 2022. Now, you hear a lot about the Omicron variant now. Well, if you remember, there was first the Delta variant. And that was why, the city implemented this testing policy to combat that surge in rising cases. So the requirement was this: unvaccinated city employees were required to submit to weekly testing and report those results to the city's employee health center. Testing was on the employee's own time and expense, and failure to comply with the testing requirements could result in progressive discipline. And also, there were accommodations for disability and sincerely held religious beliefs. And the city informed the employees that those requirements were in effect until two things happened. The COVID positivity rate in Wake County was less than 5%, and the community transmission rate was no longer high or substantial. And eventually, those two criterion were met, and the city lifted the testing requirement in April of 2022. Now, a little bit about Petitioner Steve Worley. He's a technology analyst in the city's Public Utilities Department. Importantly for today, his position is a salaried position for the city, and he's exempt from the Fair Labor Standards Act for overtime pay rules. Also, very important, he was never actually disciplined under the policy, or under the city's testing requirements, and he never forfeited any pay for failing to comply with the testing requirements. About his hearing request, so as I mentioned, Mr. Worley does not seek any lost time or back pay. He doesn't allege any of that in the hearing request. He basically challenges the COVID testing requirement itself. In support, petitioner contends that vaccines and boosters are not effective at providing protection from COVID-19, and vaccines are not effective at preventing cases, hospitalizations, or death. What he's asking the commission to do is one of two things. One, strike down that weekly testing requirement, or impose a new requirement that all city employees test weekly for COVID-19, regardless of vaccination status or accommodation status. The city contends that the commission lacks subject matter jurisdiction over petitioner's appeal. And I'll talk a little bit about the commission's jurisdiction here. As the commission well knows, that their authorities derive from the Raleigh Civil Service Act, and that jurisdiction is limited. The act authorizes you to hear appeals about violations of city policy that relate to one of the following adverse employment actions: suspensions, layoff, removal, promotions, forfeiture of pay, or loss of time. And importantly, only those issues raised in the hearing request can be heard and determined by you. And also, petitioner has the burden to prove to you that he has subject matter jurisdiction. Now, the first reason why the city believes that the commission should dismiss this case is because simply he hasn't alleged a city policy violation. He doesn't allege anywhere in the hearing request that some city policy was violated by requiring him to test weekly. He just complains about the policy itself. And the commission is not a general complaint appeals board. The commission, city employees only have the right to appeal complaints to you that are the subject of your authority under the Raleigh Civil Service Act. In other words, if there was a city policy violation related to one of the adverse employment actions, none of that's present here in this case. The second reason is that petitioner lacks standing. So even if he had properly alleged a city policy violation, dismissal is still proper because he hasn't suffered any adverse employment action that's actually appealable to you. If this case went to a full evidentiary hearing, there's nothing for you to affirm, reverse, or modify. Although he complains about having to test on his own time outside of work hours in his hearing request, he never actually asked for back pay. He never actually missed time from work. There's just nothing to adjudicate. Also, as to the request for relief that he's asking, it's moot and it's outside the commission's jurisdiction. So if you remember, the first thing that he asked for the commission to do is strike down the weekly testing. And that's been over with for almost 6 months, over 6 months now. So the issue's moot. And the second relief request that he's asking you to do is require all city employees to test. So you would effectively be making policy, and the commission is not a policy-making board. The Raleigh Civil Service Act does not authorize you to do something like that. The act also expressly prohibits you to initiate any action that affects city employees that are not parties to this action. And I believe in the brief in response to the city's motion to dismiss, opposing counsel essentially asks you to make every city employee a party to this case so you can impose the weekly testing requirements. The city believes that that's outside of your authority. So in response to the city's motion to dismiss, petitioner didn't address any of the city's arguments for why his hearing request is subject to dismissal. Instead, petitioner argues that the case should not be dismissed because requiring petitioner to test on his own time, quote, raises the issue of lost time and forfeiture of pay for uncompensated mandatory work that he should have been paid under the FLSA. Well, the commission does not have authority to decide questions of federal law. This has been addressed many times in the past with the commission, most recently in the Lands case where the commission said that it has no authority to address the FMLA. This is no different. And also, even if you could address the federal issue, he's an exempt employee, so he's not even entitled to overtime pay under federal law. And also, only those issues raised in the hearing request can be heard and determined by the commission. The FLSA issue was never raised in the hearing request. He doesn't allege loss of time or pay. Therefore, the commission just can't consider those issues. So in conclusion, because the commission can only hear and decide matters within its statutory authority, the commission lacks jurisdiction over petitioner's appeal about his complaints over the COVID-19 testing requirements, and therefore the city asks that the commission dismiss this case.
Thank you. Mr. Lawrence?
Thank you, commissioners, and good morning. This case involves a narrow question in some ways, and that is the COVID testing mandate, which the city instituted, in our view without properly routing the question before the Civil Service Commission to vet that personnel rule and presenting it to the City Council for a vote. So the policy that we're talking about today was never pre-approved by this commission, and it was never voted on by the city council, even though the Raleigh Civil Service Act talks about personnel rules having to be vetted in such a way. Never happened here. The complaint at issue, which was filed by my client in, I believe it was November of 2021, using the form that the commission or the city provides for him to fill out concerns about city policy, alleges in simple terms the factual background of why we're here this morning. And that is that the city mandated a COVID-19 vaccine for employees, the subject of which is hotly contested and is currently being litigated in federal court today as we speak. And as my colleague mentioned, concerns that Mr. Worley raised about the efficacy and safety of the vaccines and their ability to stop the transmission and spread of COVID-19. Certainly the complaint was not a law review article, and it, in our view, provides a factual basis for which Mr. Worley is in a position to make legal claims. My colleague points out that no specific city policy is cited in this document, and the city has put in place, or the city has put on evidence in the form of an affidavit that Mr. Worley is an exempt employee under the Fair Labor Standards Act, and so the FLSA would not apply to him. However, there are, again, facts that are alleged in this complaint that give rise to plausible legal claims, though they're not specifically articulated in this on the face of this complaint. Namely, when we talk about city policy, the fact that the city's violated its own non-discrimination ordinance by implementing this testing requirement, because under the Raleigh ordinances, excuse me just a second. Under subsection D of section 4-1004 of the Raleigh City ordinances, the policy of non-discrimination says explicitly, quote, that the city manager is directed to establish such policies as will ensure there is no discrimination in any function or area of city government. And this policy treats vaccinated and unvaccinated individuals differently. It requires Mr. Worley, who has not received a COVID vaccine, to get tested, even though it's undisputed that vaccinated and unvaccinated people can get COVID-19 and transmit it. And yet, he, under the policy that was revoked in April of 2022, is required to get tested. Others are not. And so, with respect to a city policy being violated, we would point the commission to that. In terms of the jurisdiction of this commission, our view is that, at the very least, that theory would allow for the commission to review the work that was done below with respect to Mr. Worley's complaint in this regard. And then, again, as we said, we don't dispute the FLSA issue. With respect to mootness, my colleague raised the issue that the policy was revoked, I believe, in early April of 2022. However, it's still possible. I think the city leaves the door open that at any given time it could reinstitute the policy and require vaccinated or unvaccinated people to test, even though we do have this, again, undisputed from a scientific perspective. Dr. Fauci talked about it. Dr. Anthony Fauci talked about it in July of 2021, that vaccinated and unvaccinated people can transmit COVID-19. And the city leaves the door open at any time to come back and to institute the same discriminatory policy again. So while the issue is not, while the policy is not currently in force, it could be reinstituted at any given time. And so for those reasons, we would ask for the commission to allow Mr. Worley's complaint to proceed and continue through the process. I would add for the commission that Mr. Worley is a plaintiff in Manson versus the City of Raleigh, which is a currently pending federal district court case in front of Judge Myers in the Eastern District of North Carolina, where some of these issues are raised. FLSA is a claim within that context. The city's authority to promulgate this mandate from a statutory perspective is live at issue in that case, though the specific issue of violating its own policy under section, again, 4-1004 of the city's policy of non-discrimination is not a live issue in that case, other than just whether or not the city has the statutory authority to implement a mandate. But I just wanted to add that context for the commission so you were aware of that. Thank you.
Thank you. Any response, Mr. Seymour?
As Mr. Lawrence pointed out, there is an active federal litigation. So a lot of the issues that he raises are points that are raised in that federal litigation. And so I can't speak to a lot of those issues because the city is represented by outside counsel in that. But I will address a handful of the issues that he raised. Specifically, he points to a city ordinance. That's not a city policy. That's a city ordinance that applies to the city. The commission, under the Raleigh Civil Service Act, it says that you have authority to review violations of city policy. And again, there's just, even today, I haven't heard any specific city policy that's been violated, but it goes back to what the Raleigh Civil Service Act says, which is only those issues raised in the hearing request can be determined by you. Also, as to his comment that the city leaves the door open for potentially implementing the policy, well, that's, again, it goes to a standing argument. I mean, you can't challenge a policy that's not implemented. You could say a host of hypothetical policies that could potentially be imposed by the city, and that's just not here today. Those were the issues that I was going to respond to.
All right. Thank you. Are there questions from the commissioners?
I just have a question whether the petitioner agrees that the FLSA, the anti-discrimination, and the CSC not approving those, that none of those were raised in the hearing request. Do you agree or want to respond to that?
I would agree, Commissioner Rubin, that my client did not specifically outline that in the form that he signed. He outlined the factual predicate to which we're obviously here this morning, and we're drawing legal arguments from the underlying factual basis. But my client's not an attorney, and so yes, he did not specifically outline count by count.
Sure. And not expecting necessarily like a legal brief, but
right.
just making sure that we're on the same page. The follow-up is which of those are in your response to the motion to dismiss? Because I don't think I saw the anti-discrimination provision in there, and I'm not sure that I saw the approval process either, but I could be forgetting.
You're right. We did not raise, and again, this was filed, I believe, in December of 2021. We raised the issue under the FLSA. We did not specifically cite to the anti-discrimination policy or the the anti-discrimination policy, correct?
Thank you.
Yes.
Are there other questions? Yes.
Thank you for that presentation. Let me make sure I understand, because of the circumstances about which we have some jurisdiction. Can both parties explain to me your position of whether or not the requirement that city employees who are not vaccinated must do testing every week, as to whether or not that is a revision of city policy?
I think our view is that there was a policy, and I don't dispute my colleagues' I think presentation earlier with respect to the timeline, that the city initially implemented a testing requirement or a test or vaccinate requirement, I believe at some point in September or October of 2021, and that policy was in effect for all the way up until the beginning of April 2022, at which point the city stepped back and said, no, we're not going to require unvaccinated workers like Mr. Worley to test anymore. However, again, and I know my colleague pointed out his counter arguments in this regard. However, the city clearly left the door open to revisit the testing requirement at any given time and to impose the requirement again on unvaccinated employees like Mr. Worley, who would then have to take time out of their day and money out of their pocket to go and test for COVID-19. I hope that answers your question, Commissioner.
I think the important issue here is that nowhere in the hearing request or the response is an allegation that these COVID testing requirements violated some other city policy, nor does he allege that the city violated the COVID testing requirements itself as to him. The only argument that I'm hearing is a federal one. And that's the argument being made in federal court. As you know, the commission is not a board of general jurisdiction. It's very limited in scope, and I understand that petitioners don't necessarily understand that right out the gate. But the Raleigh Civil Service Act is very clear in the authority that you have, and I think what we have here today is what we don't have here today is any city policy violation or adverse employment action to litigate. If this went to hearing, let's play this out. What's the issue? What's there for you to decide? And there's nothing for you to decide. I hope that answers your question. I don't know.
Can you direct us in the Civil Service Commission Act where it addresses that we can only hear what's in the original request for hearing?
Sure. It's in section 7.
Exhibit 1.
It's Exhibit 1, yeah.
Okay.
Page 4.
Sorry.
In subsection D, 7D. If you start from the bottom, I know it's a long and windy. If you start from the bottom, about 1, 2, 3, 4, 5 lines up, it starts, only those issues raised in the hearing request, or in the request for hearing may be heard and determined by the commission.
Thank you.
Sure.
Are there other questions? Hearing none, we'll open up the floor for any kind of discussion from commissioners about how you are intending to rule. Any discussion before we vote?
Well, I can go first. I think my experience here on the Civil Service Commission, because I am not a man of the legal profession, and so I sympathize with the plaintiff here about not being a lawyer and and having a thorough understanding. It's been my experience here at the Civil Service Commission that this is a pretty common occurrence with City of Raleigh employees, is that we are a very limited board of oversight and correction, and so we're very closely governed by which we can act. And so it's unfortunate that in the petitioner's original request for hearing, I don't see any way that I can make the connection from what he alleged to what now the requested relief is. And I sympathize with that because I probably would have made the same mistake because I'm not a very smart man. And so I sympathize with that greatly, but there's just no way that I can make the connection from every city employee has to be tested or no employee has to be tested to, because the argument of maybe he should have been given compensated time, so it's not, in your original argument about loss of pay and stuff like that, it's, he's exempt from that, but I think there could be an argument for, well, he should have been tested, Monday morning at 9 a.m. from 9 to 10 on the City of Raleigh's time. That's a much more compelling argument, but unfortunately it wasn't, there's no way to bring up what was originally brought up in the original brief to that. And so I think that kind of limits what our jurisdiction and what we can reach out and affect. So that's kind of my opinion on it.
I agree with all of that, and I was sitting here thinking about, because it is really important that we're not too narrow with how we read the hearing requests, since they are usually written by employees that are not attorneys. I think my inclination is that we should grant the motion to dismiss, and that we have no jurisdiction over the claim raised in the hearing request, which is essentially, it reminds me of when we had the pay scale changes, and we had a series of cases where city employees complained about the policy. And some of them were very persuasive claims about how the policy had affected them in a way that felt inequitable. But we ultimately ruled that's not something we can deal with. That's a complaint about the policy, and the city council makes the policy. And that's kind of what I read from this, is that it's a complaint about it being a bad policy, and it's just not something that we have jurisdiction over. The remaining claims that have been discussed here, I would say that they were not exhausted and they were not presented in the hearing request, and so that we wouldn't hear them for that reason. I wouldn't try and reach our jurisdiction over things like whether we were supposed to approve that or not. I don't think it's in front of us, and it's an interesting question. I think it's not one that we should decide on almost no argument, because it's not even something we've had briefing on. So in short, I would say that we should dismiss, no jurisdiction over the hearing request, and no exhaustion over the things that are not in the hearing request.
Mr. Lee? Oh. Any other discussion, or should we go ahead? Are we ready for a vote? All right. All the commissioners who are in favor of granting the city's motion to dismiss, please say aye.
Aye.
Any commissioners opposed to granting the city's motion to dismiss, please so indicate. All right, I think the decision is unanimous, and the city's motion to dismiss is granted.
Thank you, Mr.
And Mr. Seymour, I assume that you will work with counsel for petitioner on presenting an order to me.
Absolutely.
Okay.
Absolutely.
Great. Thank you. And Mr. Maccini, I don't think we have any other business today.
No, you do not. You have an updated list of your pending cases,
Right.
and that which means you have nothing until at least January.
So there's no chance that something sneaks in December?
Unless personnel says something, we're off the record, sorry. Unless personnel sneaks in and says, hey, I doubt it, especially being that close to Christmas.
And if so, it would probably be a brief meeting, not
It'd be a brief meeting.
not
It would be
an
just
all-day meeting.
the
Okay.
same, it would be a regular type thing, everything else. So happy Thanksgiving, Merry Christmas, and everything else goes with it.
Enjoy the holidays.
Thank you.
And Happy New Year.
Thank you.
And thank you, council.
Thank you.
Thank you.
Thank you, commissioners, for your time.